Trade Union Act 1926 for departmental exam, in-service exams, PSC exams, UPSC exams, UGC NET exam, SET, degree PG level exams and various other exams. The Trade Union Act 1926. The Trade Union as defined in Section 2 subsection H of Trade Union Act means any combination, whether temporary or permanent, formed primarily for the purpose of regulating the relations between workman and employer, or between workmen and workmen, or between employers and employers, or between employers and employers, or for imposing restrictive conditions on the conduct of any trade or business, and include any federation or two or more trade unions. The trade union, therefore, is a combination of regulating the relation between A. Workmen and employees, workmen and employers, A. Workmen and employers, B. Workmen and workmen, C. Employers and employees, C. Employers and employers. Then collective bargaining. Collective bargaining is a fundamental right. Collective bargaining is a process in which the representatives of a labor organization and the representatives of business industrial organization meet and attempt to negotiate a contract or agreement which specifies the nature of employee-employer union relationship. Main features of collective bargaining: group activity, continuous process, bipartite process, structured process, flexibility, industrial democracy, dynamic and complementary process. Then elements of trade union. The essential elements for the trade union are: A. There must be a combination of workmen and employers. B. There must be trade or business. C. The main object of the union must be to regulate relations of employers and employees, or to impose restrictive conditions on the conduct of any trade or business. Workmen. The definition of workmen has been included in the definition of trade dispute as provided in Section 2 subsection G of the Act. Then civil servant and trade union. I repeat, civil servant and trade union. The civil servants are not engaged in trade or business or industry and therefore cannot form a trade union. The civil servants are not engaged in trade or business or industry and therefore cannot form a trade union. Trade dispute. 1. The object of the trade union must be for resolving a trade dispute. As per Section 2 subsection G of the Trade Union Act, the trade dispute means any dispute between employers and workmen, or between workmen and workmen, or between employers and employers, which is connected with the employment or non-employment, or the terms of employment or the conditions of labor of any person. As per the definition of trade dispute has the following connotations: A. Dispute between 1. Employer and a workman, 2. Between workmen and workmen, 3. Between employers and employers. Then C. The dispute must be connected with the following: 1. Employment, 2. Non-employment, 3. Terms and conditions of employment, 4. Conditions of labor of the workman. Then registration of trade union. Mode of registration. The requirement of registration of trade union is not compulsory. The registered trade union enjoy certain benefits which an unregistered trade union do not enjoy. Application for registration. The application for registration of a trade union shall be made to the registrar and shall be accompanied by a copy of the rules of the trade union and a statement with the following and a statement. Okay. Then registration. The registration on being satisfied that the trade union has complied with all the requirements in regard to registration shall register the trade union by entering in a register maintained and shall issue a certificate of registration in the prescribed form which shall be conclusive evidence that the trade union has been duly registered under this act. Section 8 and 9. Then registered office. All communications and notice to a registered trade union may be addressed to its registered office. Notice of any change in the address of the head office shall be given within 14 days of such change to the registrar in writing, and the changed address shall be recorded in the register referred to in section 8. Certain acts not to apply to registered trade union. Certain acts not to apply to registered trade unions. The following acts are not applicable to trade unions, and the registration of any such trade union under any such act shall be void. A. The Societies Registration Act 1860 1860. B. The Cooperative Societies Act 1912 1912. C. The Companies Act 1956 1956. Then, objects on which general funds may be spent. Section 15 of the Act provides for the right of the trade unions to spend the general funds. Then, constitution of a separate fund for political purposes. Section 16 of the Act provides a trade union with the right to constitute a separate political fund. Then, office bearers of trade unions. As per section 21A of the Act, a person shall be disqualified for being chosen as and for being a member of the executive or any other office bearers of a registered trade union if A. He has not attained the age of 18 years. B. He has been convicted by a court in India of any offence involving moral turpitude and sentenced to imprisonment unless a period of 5 years has elapsed since his release. Then, amalgamation of trade unions. Section 24 of the Act provides for amalgamation of trade unions. Any two or more registered trade unions may become amalgamated together as one trade union with or without dissolution or division of the funds of such trade unions, or either or any of them, provided that the votes of at least one half of the members of each or every such trade union entitled to vote are recorded, and that at least 60% of the votes recorded are in favor of the proposal. Then, effects of changes of name and amalgamation. As per the section 26 of the Act, the changes in the name of a registered trade union shall not affect any rights or obligations of the trade union or render defective any legal proceedings by or against the trade union, and by legal proceeding which might have been continued or commenced by or against it by its former name may be continued or commenced by or against it by its new name. Dissolution. When a registered trade union is dissolved, notice of the dissolution signed by 7 members and by the secretary of the trade union shall, within 14 days of the dissolution, will be sent to the registrar and shall be registered by him if he is satisfied that the dissolution has been effected in accordance with the rules of the trade union, and the dissolution shall have effect from the date of such registration. Section 27. Then, rules of trade union. Provisions to be contained in the rules of a trade union. A trade union shall not be entitled to registration under this Act unless the executive thereof is constituted in accordance with the provision of the Act, and the rules thereof provide for the following matters. A. The name of the trade union. B. The objects for which the trade union has been established. C. The purpose for which the general funds of the trade union shall be applicable. D. The maintenance of a list of members of the trade union and adequate facilities for the inspection thereof by the office bearers and members of the trade union. E. The admission of ordinary members who shall be persons actually engaged or employed in an industry with which the trade union is connected, and also the admission of the number of honorary or temporary members as office bearers required under section 22 of the Act to form the executive of the trade union. F. The payment of a minimum subscription by members of the trade union which shall not be less than 1 rupee per annum for rural workers, 2 3 rupees per annum for workers in other unorganized sectors, 3 12 rupees per annum for workers in any other case. G. The conditions under which any member shall be entitled to any benefit assured by the rules and under which any fine or forfeiture may be imposed on the members. H. The manner in which the rules shall be amended, varied, or rescinded. I. The manner in which the members of the executive and the other office bearers of the trade union shall be elected and removed. Thank you.